2, 1. Greetings, dear colleagues, public candidates. Today, January 20th, 2025, the advisory group of experts gathered in full to conduct an interview with the candidate for the position of judge of the Constitutional Court of Ukraine, Svitlana Rieznikova. In particular, all 6 AGE members are present: AGE Secretary, Madam Maureen O'Connor, AGE members, Madam Hanna Suhotska, AGE members, Mr. Aller Zeller, Mr. Yaroslav Romaniuk, Mr. Vasil Shakun, as well as myself, the AGE chairman, Oksana Vasilchenko. During the interview, AGE deputy members are present: Mr. Marek Zubik, Mr. Thomas Griffith, Mr. Richard Barrett, Mr. Vitaly Machinchuk. I know that we work in a shelter, so in the event of an air raid, interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the resources of the AGE and the website of the Constitutional Court of Ukraine. Therefore, I draw the attention of the members of the AGE and the candidate regarding the restriction of the use of sensitive data and information with limited access live. If it is necessary to discuss such issues, the AGE will limit the broadcast at this time. We are ready to begin, so I give the floor to the AGE Secretary, Madam Maureen O'Connor, for a brief introduction of the candidate and a reminder of the interview regulatory framework. Please, Madam Maureen.
Thank you, Madam Chair. Greetings to the public, colleagues, and to the applicant. As our chair has already said, the advisory group of experts will now conduct an interview with candidate Madam Svitlana. Let me remind you that the interview and the opportunity to interview is a mandatory stage in evaluating the candidates as part of assessing their compliance with the criterion of high moral qualities. The interview is given up to 1 hour, and the time limit for answering the questions that will be asked during the interview is up to 3 minutes. Traditionally, we ask all candidates to be concise and answer clearly and unambiguously to the essence of the questions that have been asked. At the end of the interview, all candidates will be asked to make a short final statement of no more than 5 minutes. I would like to note that during the processing of materials about this candidate, the AGE sent her questions to provide written answers and explanations, so the candidate has had the opportunity to prepare for this interview and to provide answers. So now we have with us the candidate for the position of Judge of the Constitutional Court of Ukraine, Madam Svitlana, who was admitted to the competitive selection by the Competition Commission under the President of Ukraine. She is a retired judge of the Second Administrative Court of Appeals. She is also a candidate of legal sciences. In addition, she is studying in the distance learning program of the Ukrainian Free University, Munich, at the Facility of Public and Economic Sciences in the specialized discipline of international law. Madam Svitlana, if you wish to add anything to the introduction that I have made of you, you may do that now for up to 3 minutes.
Microphone.
Greetings. Thank you very much. The introduction was well structured and concise and comprehensive, so we can continue.
Шановні колеги, перейдемо до
Dear colleagues, let's start with the questions to our candidates. Svitlana Sergeyevna, we already sent this question in the written communication when we identified numerous minor violations of the declaration rules. However, we see that these violations, though being minor, are quite systematic in nature. Could you please explain the reason for this? The beginning for declaring their information was first announced for judges in 2016. Back then, there was no clarification except for the anti-corruption legislation. Therefore, we used general rules when filling out the declarations, and we were trying to provide as much information as possible. Our position was to include as much as possible to avoid any unpleasant discoveries at a later stage and to avoid violating any anti-corruption legislation acts. That is why all my numerous violations are caused by my desire to disclose as much information as possible and not by my aim to hide certain information. That is why the information that I filled out in the declaration, I believed was supposed to be included there. That is why I had certain mistakes. Thank you, Svitlana Sergeyevna. And we will just point out several facts that require more detailed analysis and explanation from your side. Namely, an analysis of your 2020 declaration indicates that your expenses exceed your income by almost 600,000 hryvnias. The AG provided you with the corresponding calculation where we were able to see the total of your income and to define this discrepancy of almost 600,000 hryvnias. Do you confirm this calculation? The thing is, if yes or no, if no, then just explain why. I do not confirm this calculation because in the last question regarding the declaration, there were the explanations provided regarding this exceeding of the limit. I understand that the questions regarding 2020 declaration were not included because the calculation of the income and the calculation of the expenses was included as a general information of paying off the loans and mortgages. From the very beginning, I stated that all my loans were paid off with the same sum of payments from my income and not at the end of the commitment with a single payment. You are speaking about the next question. Allow me to remind you. So we will go back to this question as well. However, I would like to remind you that when we asked you this in our written communication, you pointed out that you received a loan from your friend, Sergei Voitenko. Could you please tell us what proves this loan? As of today, this loan was fully paid off by me. In the beginning, I took this money to purchase an apartment in 2018, and as of the end of 2020, I paid off this loan. But you included paying off this debt in 2020. That is why there is a discrepancy in the calculation. Yes, but did it work the other way around? You said that my expenses exceeded my income for the purchase of apartment. I did not mention the apartment. I simply speak about the calculations in your declaration. So what you are trying to say, let's take a step back. You believe that there are no discrepancies. There were 45,000 loaned to you by your friend, almost 1,200,000 hryvnias, right? I'm quoting your explanation right now. Then why in the 2018 declaration you specified a different sum, 1 million of hryvnias? Do you speak about the discrepancy between million and 1,200,000? Yes, so there were two declarations. The first declaration was reflecting the changes of the owned property. That is why I specified the sum that was spent on the purchase of this property. And there was also the general declaration, 2018 declaration, where I specified the sum of the loan. It is a discrepancy. I was trying to reflect the money that I spent on purchasing the apartment in the declaration where I specify the updates in the property ownership. And then in the declaration, in the general declaration for 2018, I specified a full sum of the loan because it was a bit later. Okay, we're talking about 2018 here, right? Yes, in 2018, why did you not reflect this loan? This loan was paid off from my salary every month and did not exceed 50 life minimums. That is why I decided that it should not be reflected. Yes, but the sum of your loan that you paid off in 2018 was more than 50 life minimums. I do agree that this is my mistake. And if we put these calculations together, then I was supposed to reflect this. Can you now recall what kind of sum, what part of the loan you were able to repay in 2019 and what part of sum you repaid in 2020? I believe that in 2019 I was trying to pay the majority of the loan, and I had not only the expenses from my salary but also other incomes that I used to repay this debt. Could you specify what kind of incomes those were at the time when you were holding the position of a judge? So, my mother gifted me a house in the town of Vovchansk, and this happened after she decided to move out. So, I invested a certain sum of money in rebuilding this house so that I could sell it further and repay my loan. So can we say that in 2020 and 2018 you did not reflect this loan because you believed that I did not reflect the expenses for repaying the loan because you believed that it was not more than 50 subsistence level. Okay, we understand that. Now, you say that there were other ways of repaying this loan. Your mother gifted you a certain sum of money. Your mother gifted you the house, or and then you sold it. I mean, you had the income to repay the loan. Was this income reflected in the declaration? Yes, as an income. I reflected this as my income. But yes, and this income was also used to repay the loan. Thank you. Madam Hanna?
Micro. Yes, I have the question concerning the potential conflict of interest. In 2018, Sergei Boytenko, who is the common law husband of your close friend, lent you, as we discussed, lent you 1,200,000 Ukrainian hryvnia. According to the Unified State Register of Legal Entities, he is a member of Viola, LSC, and Avanti, Ukraine. In your answers to the written questions of the advisory group, you confirmed Sergei Voltensko's connection with Avanti. Do you confirm the information?
I learned this information when I was preparing for the interview. In order to clarify the situation, I asked Sergei Voitenko about everything, and after that, his wife explained that the certificate of birth and these firms not being functional constitute the proof for the fact that I did not know Serhiy Voitenko before his child was born, and the conflict of interest in 2011 could not occur because a child was born in 2014. Therefore, the money that I loaned from him were received in 2018. Therefore, I only knew Serhiy Voitenko. I only met him in 2014, and I met his wife before they met and before they had their first child. That is why they told me that Avanti Ukraine LLC has not been functioning since 2016 or 2014 even, and Viola LLC provides polygraphic services has been providing them for maybe 20 years already. However, this information was discovered by me during my preparation for the interview.
Я відповіла на ваше.
Did I answer your question?
Only I have some additional question. So, because I would like to make me sure that in your opinion, there was not conflict of interest in this case, and you should not recuse yourself in this case. Because please explain much more details your position. How long you know your friend and the relation with her husband or partner, I don't know how to call it, in a civil marriage, Serhiy Voitenko. Because important is a conflict of interest when you judge the case.
I met my friend when I was 20. When I started working as a judge at Chuhuyev, the first instance court, I did not keep in touch with her. And then we started talking again when we learned that we were both expecting, so this is when we reconnected. Before then, and before our children were born, I only knew my friend. I did not get acquainted with her civil husband, so when the conflict of interest could occur, it was only after 2011 in 2014. And the certificate of birth and my explanation proves that there was no conflict of interest. And this information is something that I received when I was preparing for the interview.
You didn't realize when you judged the case, when you had a problem with Avanti, that it is a, how to say, partner of your friend?
As of proceedings on the case, I was not aware that my friend's partner is Serhiy Voitenko.
So, in this case, I have no more question.
Світлана Сергіївна, ось ці
Svitlana Serhievna, coming back to the questions regarding the violation of your declaration. When you do not specify the source of income and the source of expenses, and sometimes you cannot explain how exactly you repaid this or that loan, they lead to these additional questions. When reviewing your declarations and your written explanations, we see that you had systematic credit commitments and you were repaying them. So we would like to learn more about this, namely the declaration for 2015 and 2016. Your total income before taxes was 298,000 hryvnias, and your monetary assets in total amount of 169 hryvnias.
And at the same time, in 2016, you acquired 2 residential buildings, a land plot, and also you borrowed money to a third person. So, if we sum up all of your expenses during this period of time, then the balance on a monthly basis was about 8,000 hryvnias per month. Was it enough to live together with your child, to repay credits from this amount? The matter is that those funds that I borrowed had been borrowed much earlier, but I borrowed them. I borrowed them to my acquaintance in pots. So once I was preparing for the birth of my child, I asked her officially to make all of these documents for me, that there was this debt from her. But once she registered all of that officially, I had the right and the possibility to declare them. So it looks like these funds were borrowed during that period of time, when this official document was prepared regarding this amount of money that I borrowed. Tell us, please. Have you provided any supporting documents regarding the fact that you borrowed these funds to your friend before 2016? No, I have not provided. I have no confirmation of that. And at the same time, you were repaying credits as well, in particular the credit for your car, Audi Q3, and the monthly payment there was in the dollar equivalent about $400-500 per month. With Audi, no, I'm talking about this particular year. With Audi, it happened that those amounts that were calculated in dollars, the currency exchange rate changed, and the hryvnia credit became much smaller. So that's why we cannot understand it that I was paying this credit all the time using the currency exchange rate in dollars. We can only understand it that the car was bought in hryvnia equivalent, and then the hryvnia credit was paid. Okay, what was the amount in hryvnia? Approximately. It was 2015? Approximately. I cannot tell you. So, out of 8,000 hryvnias, minus this particular amount that you were repaying for Audi, that was enough for your life, right? You believe that it was enough. I believe that funds were used not in the way that they are specified in calculations. That's why we are asking, because there is some lack of logic. Besides, you bought Audi in 2013 and again using credit funds, right? Yes. And starting from 2013, you were repaying this credit. And again, we have a question. If we follow your explanations that it happened on a monthly basis, then we have a question. How can your monthly income, with deduction of those expenses, including credit repayments, were enough for a family to live on? That's why we are trying right now to clarify all of this during the interview, because you were repaying credit after credit. Information from the declaration on repayment of these credits is not there, so we have the impression that they were repaid not on a monthly basis. So that is why we are coming back to these questions relating to, for example, Audi. You started talking about that. When did you repay the credit for Audi? Can you remember that? You bought the car in 2013. For how many years did you repay the credit? As of the moment of the sale of the car, the credit had been repaid completely. That's for sure. But how these credit payments were made, I don't remember. I cannot recollect that. Okay, then why didn't you reflect that you had this financial commitment under the credit? Financial commitments under the credit? Yes, I mean, you took a credit in 2013 to buy the car, and in 2014 to 2017, you did not reflect anywhere in your declaration that you had a financial commitment to repay the credit. Once I took the credit, I reflected this amount of credit commitment in 2013, yes. So we have the impression that you repaid the credit in 2013 because you did not reflect it in your declarations for 2014 to 2017. So what was the source of origin of funds to repay the credit in 2013? Do you understand the question? Yes. Since I did not reflect expenses on repayment of credits, you made a conclusion that I fully repaid the credit in 2013. Yes. So how did you repay it in 2013? For how many years did you repay the credit? Do you remember that? The car was sold in 2017, and during this entire period of time, I was repaying the credit. Okay, in 2017, you bought a new car, Mazda, and you got a credit for it again. The matter is that the car that I was selling, it was close in terms of its sale price to Mazda's price. And since I'm a woman and I do not know repairs of cars that well, I wanted to buy a new car so that I would not have to perform this repair works all the time. That's your right, it's clear. We are not asking about the model of the car, why you bought it. That's your right. We have another question. Again, we are talking about financial commitments. Can you please tell us, how did you make payments under this credit and you took it in 2017 as far as I understand? In 2017, the funds that I received from the sale of audio were used to buy Mazda, plus you took a credit again. How did you repay the credit here in this case? How were you doing that? Mazda was owned by me only for a year, and the funds that I received from the person who was buying this car, I used them to repay a part of the credit. I cannot reflect the monthly payments for the credit repayment, but as of the moment of the sale of Mazda, I used not my own funds, but I used the funds that I borrowed from the sale of this car. No, wait. You bought Mazda in 2017. You took a credit, yes. When did you sell it? Next year. So, during this 1 year, you never paid the credit payments? No, I did pay. I would remind you, did you pay them on a monthly basis? And you paid 18,310 hryvnias per month, yes? That's approximately $700 per month. Your own funds were enough to make these monthly payments. Do I understand it correctly? Yes. Again, why didn't you reflect that in the declaration? Because 18,000 per month. My thinking was that the monthly payment should be 50 subsistence minimums. That was my mistake, my global mistake. Thank you. Thank you for your answer. I think, Svitlana, that you follow the work of the AGE and you've paid attention to thorough attention paid by the civil society organizations to the competition, and we also talk about the importance of all of this. And we are talking about the importance of court decisions in proceedings under Article 130 of the Code of Ukraine on administrative offenses, and that is about drunk driving. We've asked you some questions about this case. In particular, you considered 14 cases when you were working as a judge of Chuhuiv City Court of Kharkiv region. Here, the question is that the AGE noticed one case, and we've asked you about that, and that's the same person who was brought to administrative responsibility under this Article 130 of the Code of Ukraine on administrative offenses within a year. For the first time, you applied to the person the sanction in the form of public works. And for the second time, the same person received a fine during the same year, and when the same person in the same year again committed the identical offense, that is, was drunk driving, this person evaded responsibility basically because the proceeding was terminated due to the expiration of the term for bringing to responsibility. In your opinion, such information, can it show some sort of the lack of integrity while performing the duties as a judge? Or do you have some explanation for this fact? The matter is that all materials on committal of administrative offenses were not selected by a judge, but they were allocated by the distribution system. And when this offender, when I received the case regarding this offender for the first time, I decided on community service for this offender because I believe that this is a harsher punishment than a fine. The question about this person coming to me for the second time under the case, frankly speaking, I did not notice that because I became aware from the question that he committed this offense again, and maybe understanding that the sanction of the article envisioned deprivation of the driving license. Maybe these materials were challenged with the police, maybe due to some other grounds, but they arrived to the court after the expiration of the term, because such high-profile cases were considered on time. And Chuhuiv is a relatively small town, so it is possible to notify the person on time about it. Honestly, I cannot explain why I decided on the fine during the second case. Maybe I did not understand that that was the same person as of the moment of consideration, because some period of time passed and I do not remember that it was like that. And with respect to this termination due to expiration of terms, I can assure you that I considered all the materials on time. And if you have that expiration due to expiration of the term, I probably did not have any other possibility to do according to the current legislation. Okay, thank you for your answer. Madam Hanna, please.
Yes, we are continuing your role as a judge. Now I have some questions concerning adoption of court decisions on the prohibition of peaceful assemblies. According to the Unified State Register of Court Decisions, as part of the panel of judges of the Kharkiv Administrative Court of Appeal, you decided to restrict peaceful assemblies. In particular, in one of the cases, a panel of judges forbids the regional organization of one of the political party to hold a peaceful assembly near the Kachanivska correctional colony due to the threat to the life and health of the participating in such a meeting. Then, in addition, in another ruling dated from July 2012, the panel supported the position of the Court of First Instance on the ban on holding a protest in the square opposite the building of the Kharkiv Regional Court of Appeal. And there was some argumentation, you maybe noted better, because it was said that picketing the court building may lead to a violation of the constitutional guarantees of the independence of judges and the prohibition of any influence of them and so on. Do you confirm this information?
Так, я підтверджую цю.
Yes, I confirm this information.
Make some comment on the validity of such a court decision. Were there sufficient grounds for the prohibition of peaceful assembly in that case?
I would like to start my answer from saying that the process of prohibition of peaceful assembly in Ukraine is regulated in such a way that the initiator of the prohibition is the self-governance body. So the body that is filled in by these parties and which is governed by the public opinion in its activities and public interests. Based on the will of persons who form this local self-governance body that is initiating the prohibition. Once this body reaches a conclusion about possible developments of such prohibition, then this body collects all the information from the police, from public health bodies and from other organizations aimed at finding out whether it is possible to hold this peaceful assembly. So basically the local self-governance body goes to the court for this prohibition, and then the court considers the ready materials. Unfortunately, or maybe contrary to the UK, for example, when it is not possible to prohibit peaceful assemblies, and the police may just prohibit this event if the police sees that there might be some riot or some unrest or some public danger from this event. So once this claim comes to the court, persons who want and who intend to organize this peaceful assembly, they are respondents and not claimants in the court case on permission or challenging of the prohibition of peaceful assemblies. So our legislation is built in such a way that the court prohibits this peaceful assembly. The term for the prohibition of a peaceful assembly and for consideration of such claims is very short. Basically, the court does not collect documents under such cases. Maybe it happens for some experiment regarding the location of this correction facility or etc. So the correct cannot request these documents because of this short period of time for consideration. Also, the motivation is impacted by this short period of time for consideration because the court immediately considers, immediately announces the full text of the decision, and this decision comes into effect at once after going through the appellate instance. So I would like to emphasize that because of the lack of time and because of the workload in the court, the decisions from the register are not motivated in a very quality way. However, the issue regarding the essence of the prohibition in the first case, when we are talking about Kachanyev Correctional Facility, all the certificates from the bodies prohibiting it were provided. Yes, it was about public health, but this motivation was not the key ground for this prohibition. The key ground for the prohibition was the fact that intentions of protesters consisted in being located on the road. This correctional facility is located in such a way that if you start the protest there and if you do not regulate it, then it will stop the traffic. So the key motivation was this, but probably because of the lack of time and a huge workload, it was not properly reflected in the motivation part. That's my explanation regarding this Kachanev Correctional Facility. And now, with respect to the Court of Appeal at Rudneva Square, located in Kharkiv, even if we imagine the square and the number of persons who were supposed to be there, 2,000 persons, this square could not host such a number of people, and prohibition was there not because there would be impact on the court, even if they wanted to locate their protest inside the court premises, but if it were somehow registered and the number of people who wanted that would be smaller, then it would be a protest. But a collection of people in a place where cases are considered, where defendants were brought, where cases are heard all the time in the court hearings, and the number of such people is 2,000, that became a ground for this decision. So I believe that that was it is necessary in a democratic society, these meetings and protests by people, but their organization should have been more well thought and more agreed with bodies of governance, including the police, the administration of the court, so that this protest would be organized and that they could express their opinion, not by means of collecting lots of people who wanted to take part in the assembly, but by means of clarity of their demands and purposes of their protest in a properly arranged way.
So you are of the opinion of support, the opinion that there was sufficient grounds for the prohibition of peaceful assembly, that because your argumentation showed that you are fully in favor of banned peaceful assembly, not, how to say, very clearly make argumentation why, but because it was also against not only collective right, but also individual right of the people, yes, to take part in such a assembly. So, but you are of the opinion that everything was well granted in this panel when you took part.
This was based on the civil interests of a democratic state, not only by the interests of those who wanted to protest, but also those who were coming to the court for legal proceedings. That is why, to keep the balance of these interests, we had to prohibit this protest. However, if we speak about the motivation part, I do believe that it was supposed to be more comprehensive and more complex. And I do say that we did not have enough time to provide a better motivational part due to the workload at the court.
I don't know, do you think that is a good argumentation that you have not enough time to make a decision in such a crucial and such a sensitive issue like the human freedom? And so for that reason, making this argumentation that it is workload and the short of time and the court has make such a decision is a exactly good argumentation, especially for candidate who is running for the position of the judge to the Constitutional Court. And then what will be happen in the Constitutional Court? You will also use the same argumentation. I think that it could be very dangerous for society, for everybody who observes the situation.
I fully agree with you. The decision was not motivated well enough, and we were supposed to do a better work on them, to make them more argumented. However, due to the lack of time, we made the decision that we made. Unfortunately, this is not the reason, and this is not the explanation for prohibition of public picketing and protesting.
In this case, I have no more question, yes, but now we are going to another one. According to the information available to the advisory group over the past 3 years, you have been brought to administrative responsibility 20 times for violating road safety rules. 2022, 13 times, 23, 6 times, 24, 2 times. In addition, during 2023, 13 enforcement proceedings were opened against you in connection with violation of the terms of payment of administrative fines. Do you confirm this information?
Yes, I do.
Consider such behavior acceptable in society and for society, because we are talking on transparency here.
I believe that such behavior in society that lives in a full-scale invasion is caused by the desire to go to the shelter and to protect one's life. And I would like to say that before the beginning of full-scale invasion, I did not have any violations. We were living the life that allowed us not to choose between public interests and legal behavior and safety. So, if I had the cases of violating road safety, they were related to the fact that distance from my house to my working place is quite significant, and I was either in a hurry to get to work on time, or I was supposed to go to the shelter due to air raid. And this was the reason, those were the circumstances for violating road safety. Those were the violations of exceeding the speed limit. Unfortunately, this was the case. All fines that were appointed were paid by me, since in the beginning of full-scale invasion it was difficult to track these fines. I was not informed about them. I would not receive notifications in the DIA application, and once such opportunity appeared, I was able to track all the fines and to pay all of them. I would like to once again emphasize that this was a necessary forced measure when I was deciding between the safety and the violation of a speed limit.
But you know, it has happened. It took place 20 times. Yes, so you were always in a hurry 20 times. But you know, it happens once. Yes, maybe twice. But then you have better calculated your time in such a situation. And do you think that this argumentation you presented to us, to the AG, is exactly convincing for society? Because it's such an example for everybody. Yes, that everybody being in a hurry and can how to say, break all the rules.
This behavior of mine indicates that I did have violations, and these were forced violations due to the circumstances in the country. I'm not trying to find excuses in this situation. I own to the fact of having these violations, and I explain them by the long distance between my house and my working place. It is approximately 200 kilometers. And when you are in a rush and there is a speed limit camera that documents and records your violation, this is one case, and you are able to get these violations multiple times when you go through the way of 200 kilometers. It is not 20 days occurrence. So I was expecting the fines in future, and I was trying to organize my commute in a better way so that I would be more responsible.
Це
Yes, but you know,
недопустимо
there
в
are also other
суспільстві.
questions because, for example, according to the advisory group according to the knowledge of the advisory group, on the 21st of January 2017, you were brought to administrative responsibility for violating the rules for using seat belts, as a result of which you paid a fine. But you know, you always violated such rules. We are now in year 2017. There were no such a situation of war, nothing specific, and why you did it?
I cannot explain this.
Not reflected in the declaration, a relevant fact in paragraph 22 of the judge's declaration for integrity for 2017, because you didn't mention it.
So it happened in 2017, and it was one violation. And to say that I remember this fact for now, that I remembered this at the moment of filling out the declaration, I cannot say that. Obviously, paragraph 22 must reflect the facts of violating the rules in the judge's declaration of integrity. However, at the moment of filling out and submitting this declaration, I did not realize that I was supposed to reflect this exact violation, the violation of the road safety rules. In my opinion, I was supposed to reflect the violations of a judge and not the violations that happened in my personal life, apart from my performing of the duties of a judge. That is why I can neither deny nor confirm that I paid this fine, or because at this time I do not remember that. And as of 2017, when these declarations were introduced, I believed that paragraph 22 was supposed to reflect the facts of violation related to my professional activities. That is why I did not reflect this violation of road safety rules.
But you know, here our role as a AG is also how to say analyze integrity of the person who is asking for being a judge in the Constitutional Court. So you know, integrity means that we have to analyze your behavior as a person and your behavior as a judge, because its common behavior can create integrity of the person, and for that reason we put you such questions which are for you personal, but they are integrally connected with your, how to say, personal integrity, I can say. You can understand, yes, why are the questions, yeah. We should not put the personal, how to say, person separately from the person acting as a judge, because it should be put together. And for that reason, I would like to know what is exactly your motivation for participation in the competition for judge to the Constitutional Court. Because in response to the written question of the advisory group about the reason for your dismissal from the post of judge, you indicated that the only motive is the inability to combine work and raising a child. In addition, you have now left for England and your daughter is studying at the local school, which requires your permanent presence in England. So, taking into account these circumstances, how you will be able to perform a work of judge of the Constitutional Court in case of your appointment, because your indication and motive for resigning from being an ordinary judge is also acting against the post Constitutional Court. What kind of argumentation you can use, convince us that you be exactly a good candidate for a judge to the Constitutional Court?
So, if you ask me why I left the post of judge, I can say that I have a child who is a minor, and starting from the full-scale invasion, my child was receiving her education online, and I can definitely say that the access to education is limited for her, and I see that her level of knowledge changes dynamically. And I believe that the reason for this is lack of accessibility of education, as well as the location of my house and my working place. Taking into account the fact that the Constitutional Court conducted competitions multiple times, but those competitions were considered void or unsuccessful. This was the first motivation for me to participate in the competition and not to leave my country in the circumstances when it needs the formation of all organs of the state, which are the attributes of the state. And at the stage of the formation of my direction to constitutionality was polished by my studies in the institute in Munich. That is why, when I started my education there, I decided that my education and the upbringing of my child will be two primary directions that I will be supporting in the period of full-scale invasion. However, when I analyzed the situation in the country, I decided to turn to the Commission with the request to consider my candidacy for the position of the judge at the Constitutional Court of Ukraine. First and foremost, I have a citizen's conscience. I'm also experienced in law, and I believe that the decisions of the Constitutional Court allow other courts to resolve their cases. Moreover, the opportunity for additional education allowed me to take a different viewpoint for the Euro integration for Ukraine, and I gained the understanding of the directions that should be reflected in the activities for the Constitutional Court for further integration in the European society. And with the assistance of interpreting the key laws and the key changes and demands that take part now, in order to provide a clear understanding of the processes for further court instances, I believe that my experience can be useful. And that is why I applied for this competition, to perform the function of the judge of the Constitutional Court aimed at the protection of the citizens' rights in this society, where we move away from European values due to the full-scale invasion, and where and I believe that going deeper in this direction, I have sufficient experience and I have an intention to fulfill this once I am in Ukraine and once my child can go to a school offline and I can go to work and perform the duties which I take up on based on the result of competition. Thank you. Madam Hanna, any other questions to the candidate?
I have no more question. Thank you.
Шановні колеги, чи є запитання?
Dear colleagues, any other questions to the candidate? I have a question. You're the candidate of legal studies, yes. Could you name the name of your thesis? Administrative law enforcement of the disciplinary practice in the courts of Ukraine. And who was your scientific supervisor? Salmanova Olena Mykolaievna. Where did you defend your thesis? I defended my thesis in Kherson, in the Institute of Business and Law. There was a scientific council. Thank you. What publications do you have as a result of defending your thesis? I tried to create the material that will be useful. Please be specific. Publications, articles, 1 or 2. Let's say I had published my articles before I defended my thesis, and once I defended my thesis, I was working on the scientific and practical commentaries for the customs code, administrative code. Understood. Thank you. And one more question. Your daughter now studies in England, as of now, yes, and you stay in England with her. At the same time, you're participating in the remote program of the Institute, Free Ukrainian Institute in Munich. I wanted to ask you, all these activities require both time and sufficient funds. How are you able to afford this?
The funds that I used for my trip and for transportation of my child and dog to England, I used my money that I receive due to retirement. Okay, clear. Can you please tell us? As a rule, you need to live there. Where do you live in England? What's your place of residence? Do you rent it, and what's the price? In England, there is the program for Ukraine, which envisions that until the moment the person, the Ukrainian, who decided that he or she would relocate to England, they should get acquainted with their sponsor, that is the host, that is the local citizen who wants to locate Ukrainians either at their home or in a separate home that they have. And for that, sponsors submit applications, then these applications are considered, and depending on that, you get accommodation. So accommodation is free of charge. And I spent time and money so that I could drive from Kharkiv using my vehicle to Devon, and my sponsor was located there. Upon arrival to England, within a week, funds are paid, which can be used for a monthly living. So this way, the funds that I spent on transportation were enough to get to England. Tuition fees were paid by me before that, because payment there happens once every 6 months, and that is 600 euros. That's the tuition fee. Where? In the institute where I study online. Okay. Okay, clear. Thank you. Madam Marin, yes, please.
Excuse me. Madam Svitlana, do you intend to return to Ukraine?
Yes, yes, I intend to come back to Ukraine, and as soon as the issue with the results of the competition is resolved. So,
If you are not selected, if for some reason you're not selected, will you remain in England?
Так,
yes.
так.
All right, if you
Певний час буде
For some time, yes, I will remain in England because this is the program that allows me to stay there until April of 2026. But no longer than that. That is a specific period of time that is dedicated for us, that is kind of a service for shelter against the war. It's not, it does not envision that I can stay there based on legal grounds after the end of this situation in the country. All Ukrainians have to come back to Ukraine after that, and they have to work in order to develop the economy of their country.
And if you come back to Ukraine, if you would get this position on the Constitutional Court of Ukraine, would your child come back with you, or would your child stay in England with the sponsor for her education?
My child and I went to England because education that is provided in Kharkiv region is related to the circumstances in which Kharkiv region is. I know for sure that in Kiev region there are schools which work, and there are schools in Myrhorod which also work, but for some time they work online, sometimes they work offline. So I do plan. In case I get a successful recommendation for the position of the judge of the Constitutional Court of Ukraine, I plan to come back together with my daughter, who will have the opportunity to go to Ukrainian school, and I will have the opportunity to work in close to her, so that I could follow her development and education at this time.
Thanks for the answer to that. Now, you made a statement about your 20 traffic violations, that it didn't happen over 20 days or 20 separate trips or drives, that there were cameras, and so if you were driving a distance and there were multiple cameras, each one of those cameras recorded a violation. Is that your rationale? That's your reason for the 20?
The matter is that I was going from Myrhorod to Kharkiv, and the violations that were recorded by video cameras, I did not trace them on gadgets. I did not get any notifications in any apps. I did not get the notifications in PrivatBank or Dia app, and moreover, during the period when they were committed, all the signs, road signs regarding settlements, which had to be located on both sides of the road, they were like redacted. They were removed. So, because of the situation.
Excuse me, I'm not asking you about the circumstances that you didn't see the cameras or you didn't know the cameras. Did these violations happen all in 2 trips, 5 trips? How many drives resulted in your violations?
As far as I understand, several violations were committed on one day. So it was like 3 or 4 trips. It was explained because of the long distance that I had to drive during the trip, and the location of these cameras. On some of them I was recorded, some of them did not record me. So I did not commit violations of the rules during the entire distance. I just committed some violations along this distance of 200 kilometers. But it was maybe 4, 3 or 5 times. So these were forced violations related to the situation in the country that existed, but it was not related to my desire or undervaluing of the traffic rules.
I understand what you're saying about your respect for traffic rules, but I also heard you say that you were rushing to get to work on time so that you wouldn't be late. That you mentioned that. So you also mentioned that you were trying to seek shelter. There was an alert, a safety alert, that you needed to get to a shelter. Now, is that true?
Those are the circumstances that could become a ground for a violation of traffic rules by me.
Or are?
Були.
Where?
Що поспішали.
Yes, I think that rushing to work is not the main factor. Because when you drive and when you hear the air raid alarm, maybe during this period of time I try to leave the road and to find a shelter where I could seek shelter. But when you're driving in the middle of the field and when you do not see the signs that regulate the speed of movement because they are redacted, in such cases maybe I committed violations of traffic rules without even being aware of existence of some speed limitations during this particular segment of the road. So not 100 but 60 kilometers per hour, maybe that was a settlement.
Thank you.
Dear colleagues, do we have any other questions? If there are no other questions to the candidate, Ms. Svitlana, now you have the up to 5 minutes to address us with concluding remarks, please. I would like to say a huge thank you for calling me up so quickly and for conducting this competition in such an organized way. I feel sorry that I did not wait for your answers and for this invitation to the interview on the territory of Ukraine, because that man, that sponsor, invited us to England. But with my soul and thoughts, I'm close to Ukraine. I'm close to those processes that are ongoing in Ukraine. So this has become a ground for submission of these documents for participation in the competition for such an important position in our country. Thank you for your attention and thank you for cooperation. Thank you, Svitlana, for your answers. Dear colleagues, dear public, now I am declaring interview with the candidate for the position of the judge of the Constitutional Court of Ukraine, Svitlana Rieznikova, completed.